Picture this for a second. It's a humid, beautiful afternoon in the Caribbean.
Okay,
You're standing on the deck of a massive, gleaming cruise ship. Maybe you've got a mojito in hand. You know the whole 9 yards.
I'm with you.
Your ship pulls into the port of Havana. You see the historic skyline, the crumbling colonial architecture, the vintage cars driving along the Malcon. You dock at the pier, walk down the gangway, and start your vacation. It looks like paradise, right? A time capsule.
A vivid image. It's the kind of thing travel brochures are made of.
Exactly. But here's the twist. Legally speaking, you might effectively be walking onto a crime scene.
A crime scene?
Well, at the very least, the scene of a massive civil lawsuit worth hundreds of millions of dollars because that pier you just walked on, it's the center of a legal hurricane that goes all the way to the U.S. Supreme Court.
It really is a fascinating case. We are talking about Havana Docks Corp versus Royal Caribbean Cruises. What makes this deep dive so interesting is that it sort of collapses time. It matches up the Cuban Revolution of 1959 with the modern crew of tourism industry of 2016. It's a ghost story, a history lesson at a billion-dollar corporate showdown all wrapped into one.
I'm noticing a theme here, Cuba. On February 23rd, the Supreme Court hears this case and another case involving similar issues rooted in the Cuban Revolution, ExxonMobil versus Corporación Cemex S.A., Cuba. We previewed that case yesterday. Check out that preview to learn about it.
And while we're at it, a quick reminder, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Also, follow on LinkedIn to read written rundowns. Just search the High Court Report. Questions about this case? Reach out to us via LinkedIn at the High Court Report.
All right, here's what you need to know. Here's another scene for you to imagine. You build dock facilities in Havana Harbor in the 1950s. Castro takes power and steals everything you own. 60 years later, major cruise lines start making millions using those exact same docks.
Wait, and you get nothing?
That's the fight. Congress passed a law saying if companies profit from stolen Cuban property, the original owners can sue them in American courts. But here's the kicker. The cruise lines argue they can't get sued because the original owner's lease would have expired by now anyway.
Even though that lease never actually expired because, communist revolution.
Here's the two questions the Supreme Court must answer in this case. First, when someone traffics in Cuban confiscated property, do you have to prove they trafficked in property you currently own a claim to? Or do you have to prove they trafficked in property you would still own today in some alternate universe where Castro never took power?
That second option sounds bonkers.
Right? But that's exactly what the 11th Circuit Court of Appeals said you have to prove. The second question, when Cuba confiscated Havana Docks property, did they confiscate the physical dock structures that cruise ships actually use, or just an abstract legal right to operate those docks?
Why does that distinction matter?
Because if Cuba only confiscated abstract rights, and those rights would have expired anyway, then cruise lines can use the physical docks without owing anyone money. But if Cuba confiscated the actual dock facilities, then using those facilities counts as trafficking, no matter when some lease would have expired.
Let's rewind to 1913. The Cuban government grants Havana Docks Corporation a concession to build and operate dock facilities in Havana Harbor.
What kind of concession?
Think of it like a really long-term lease with benefits. They could build docks, charge ships for using them, collect fees. But here's the key detail. This covered cargo operations only, not passenger services.
So when cruise ships bring tourists, that's passenger service?
Exactly. Havana Docks extended this concession multiple times over the decades. The final version ran until 2004. Then Castro happens. October 15, 1960. Castro issues Resolution 3 declaring nationalization by means of forced expropriation of U.S.-owned companies. He specifically names Havana Docks Corp. among 165 companies getting their assets seized.
How did this actually go down?
November 21, 1960. Armed Cuban officers show up at Havana Docks offices. They take over the facilities and force the company to surrender the corporation with all its assets and liabilities. No compensation, no negotiation, just armed takeover.
And then what?
Nothing. For 60 years, the docks sit there under Cuban government control. No American company gets compensated. The U.S. government certifies Havana Docks' claim for $9.18 million, nearly $100 million in today's money.
When do the cruise lines enter the picture?
2016. Major cruise companies, Royal Caribbean, Carnival, Norwegian, MSSC, start offering tourist cruises to Cuba. Where do they dock? The exact same facilities Havana Docks built and operated before Castro stole them. And Havana Docks says, wait a minute. They sue under the Helms-Burton Act. That's the 1996 law Congress passed saying if you traffic in Cuban confiscated property, the original owners can drag you to American court. Ring a bell? It's the same law that's the focus of the case we just mentioned. ExxonMobil versus Corporación Cemex, S.A., Cuba.
How did the courts rule?
The district court initially sided with Havana Docks multiple times, even though the judge flip-flopped on the reasons for Havana's victory. But then the 11th Circuit reverses everything. The majority creates a counterfactual analysis test.
What does that mean?
The Ninth Circuit announced this test to apply to see if Havana Docks should win. What would have happened to this property in an alternate universe where Castro never took power? Since Havana Docks' concession would have expired in 2004 and the cruise line started operations in 2016, the majority says no trafficking occurred.
But Judge Brasher dissented?
Oh, he went off. Called the majority's approach incompatible with the text of the act. He argues the statute protects people who currently own claims to confiscated property, not people who would own property in some hypothetical parallel universe. The Supreme Court granted cert to decide this case, presumably due to the huge ramifications. The 11th Circuit handles most Cuban property cases. A narrow interpretation basically guts Congress's main tool for pressuring the Cuban regime.
The United States government actually filed a brief supporting Havana Docks and will participate at oral arguments. I imagine the justices will give their position considerable weight. Let's break down what Havana Docks argues. Their first argument, the statute's text controls everything. What does the text actually say?
Any person who traffics in property, which the Cuban government confiscated, shall face liability to any United States national who owns the claim to such property. Present tense, owns the claim. Not would own the property or used to own the property.
Exactly. Havana Docks says Congress intended liability to depend on current claim ownership, not hypothetical property ownership in alternate timelines. What about the types of property Congress wanted to protect?
This gets really interesting. The statute explicitly covers contingent, future, and time-limited interests. It specifically mentions patents and leaseholds.
Why does that matter?
Because most Cuban property confiscations happened in 1960. Patents from 1960 would have expired long before Congress passed this law in 1996. But Congress still wanted to protect claims based on those expired patents.
So under the 11th Circuit's logic, Congress protected property interests that already lacked any remedy?
Right. That makes no sense. You don't write laws to protect dead claims.
Havana Docks' second argument focuses on what property actually got confiscated. They say the court focused on the wrong thing. Instead of asking about the abstract concession rights, they should ask about the physical dock facilities.
What's the difference?
When Cuba confiscated Havana Docks' property, they didn't just cancel a lease. They seized control of actual dock structures that Havana Docks had built with their own money over decades.
So the cruise lines aren't using some abstract legal right. They're using concrete physical facilities.
Exactly. Facilities that Havana Docks constructed and Cuba stole. The Foreign Claims Settlement Commission's certified claim reflects Havana Docks' interest in that physical infrastructure.
Third argument, congressional purpose. Congress found that Cuban property confiscations represent the largest uncompensated taking of American property by a foreign government in history. They wanted to deter companies from collaborating with the Cuban regime to exploit stolen property.
But the 11th Circuit's narrow rule defeats that purpose?
Completely. Under their test, time-limited interests disappear as years pass. Future interests become unprotectable when contingencies remain uncertain. Companies can exploit confiscated property, knowing most claims will fail the counterfactual test.
Now let's hear what the cruise lines argue. The cruise companies make three main arguments. First, Property law fundamentals require respecting the original limits on property rights.
Meaning what?
They argue that time-limited interests like Havana Docks Concession can't magically transform into perpetual rights just because Cuba confiscated them. They use this analogy. No one would argue that owning a baseball field in Havana gives you the right to sue someone who uses a neighboring park half a mile away.
So, spatial limitations matter.
Right. And they argue temporal limitations matter equally. If Havana Docks only had rights until 2004, those limitations should still apply even after confiscation.
What about their second argument?
Use limitations. They point out that Havana Docks' original concession explicitly excluded passenger services. They could only handle cargo operations.
And cruise ships bring passengers, not cargo.
Exactly. The cruise lines argue they never trafficked in Havana Docks' specific property rights because they provide completely different services than what Havana Docks ever had permission to do.
Their third argument attacks Havana Docks' policy claims.
How so?
They say Congress deliberately balanced deterrence goals against property law principles. The statute doesn't provide universal relief for everyone who suffered any confiscation-related injury.
What's their concern?
They argue Havana Docks' interpretation would create massive windfalls by letting people with limited property interest extract rents far beyond what they originally paid for.
What does the United States government argue?
The federal government filed an amicus brief supporting Havana Docks, and their arguments pack serious punch.
What's their first point?
Claim ownership controls, not property characteristics. The statute creates liability when defendants traffic in confiscated property against someone who owns the claim to that property. It doesn't matter whether the underlying property interest had temporal limitations.
The government argues that certified claims already account for any limitations through their valuation. There's no need for additional restrictions on the right to sue.
Second argument?
Physical property confiscation. They support Havana Docks' position that Cuba confiscated the actual dock structures, not just abstract concession rights. The government uses this analogy. Imagine Cuba confiscated a commercial building with both a landlord and tenant. If someone later uses that building without permission, both the former landlord and former tenant could sue the current user.
Even though they originally held different types of property interests?
Exactly, because the confiscation affected the physical building that both parties had interests in. Third argument?
Foreign policy imperative. The government calls Title III an essential pillar of United States foreign policy toward Cuba's hostile and anti-American regime. They argue the 11th Circuit's narrow interpretation would eliminate a wide array of suits that Congress authorized, and that would, in the executive's view, advance important foreign policy objectives.
So this isn't just about one company's lawsuit?
Not at all. This affects America's broader strategy for pressuring the Cuban government to compensate victims of confiscation and stop encouraging foreign investment in stolen property.
Time for what this actually means. If the cruise lines win, what happens?
Companies around the world get a roadmap for exploiting Cuban confiscated property with minimal legal risk. All they need to do is wait until original property interest would have expired, then argue no trafficking occurred.
And that defeats the deterrent effect Congress intended?
Completely. Instead of thinking we might get sued for millions, companies think we just need good lawyers to argue about counterfactual property ownership. But if Havana Docks wins,
it preserves Congress's tool for pressuring the Cuban regime. Companies know that profiting from confiscated property carries real legal and financial risks in American courts. Plus, it reinforces that when Congress creates a private right of action, courts should interpret it to actually provide meaningful remedies. The foreign policy stakes here are enormous. Cuba has spent decades trying to attract foreign investment by offering infrastructure built with stolen American property. This case determines whether that strategy faces serious legal consequences.
looking ahead to oral arguments, what should we watch for?
First, expect the justices to really press both sides on the statutory text. When Congress said owns the claim, did they mean current claim ownership or hypothetical property ownership?
What about the scope of confiscated property?
That's huge. Did Cuba confiscate abstract legal rights, or physical dock facilities? The answer determines what counts as trafficking.
Also, watch for questions about congressional intent. The justices will want to know whether Congress really intended to protect claims to property interests that would have expired before the law even got passed.
Any predictions?
The textualist justices will focus heavily on owns the claim versus would own the property. That present tense language looks pretty strong for Havana Docks.
And the foreign policy argument?
When the federal government says a court decision undermines American foreign policy toward a hostile regime, that carries weight with every justice, regardless of ideology.
Bottom line time. Why does this case matter?
Because it determines whether Congress's main tool for pressuring the Cuban regime actually works. Cuba confiscated billions in American property and never paid compensation. And Congress responded by creating a private right of action.
But if courts interpret that right so narrowly that most claims fail, then Congress might as well not have bothered. The deterrent effect disappears, and victims get no remedy.
But if Havana Docks wins,
it reinforces that when Congress creates private rights of action against foreign regimes, those rights should provide meaningful remedies. Companies thinking about profiting from confiscated property will face real legal risks. The stakes go way beyond one lawsuit. This case defines American foreign policy toward Cuba and sends a message to other hostile regimes about the long-term consequences of confiscating American property.
That's Havana Docks versus Royal Caribbean. We'll definitely follow this one closely. Oral arguments should be fascinating. Tune in here for coverage.
Please rate, share, subscribe, follow, and support the High Court Report. You can find us on Apple Podcasts, Spotify, YouTube. Just search the High Court Report. Talk to you soon.